Hello there. We're here with Malpractice or Trial by Media. I'm sorry I'm late today, 7 minutes, but we are here. We're gonna have a great conversation. I'm gonna talk to you guys today directly from the determination and order that the OPMC issued. We're gonna speak directly from that particular order, and I'm gonna go over a few different things related to how they made their decision that branding was the practice of medicine. So, buckle up, here we go. Hey Jean, how's it going? Hi, I know, Monday. Tomorrow I have a business meeting, so I didn't want to stiff you guys and not show up and not come to talk to you, but there's a really great opportunity that I have been presented with, and I want to make sure that I give it the due diligence it needs. So I am here on Monday with you guys and wanted to make sure that we had a chance to talk. Hey Desiree, how's it going? Is that Jamie Cliff? I haven't met you before, so just leave your first name in the chat and I will then be able to call you by your first name. I usually try to remember everybody's name. So anyway, how are you guys doing on this great Monday evening? I'm sorry, I'm spinning a little bit. I was running late, so I just gotta calm down, take a breath. Do you guys like my shirt? It's RBG. It says, not fragile like a flower, fragile like a bomb. I love this shirt. Do you guys like it? Good to see you too, honey. Good to see you too. So I'm a little bummed. The woman that inspired this class, her name is Erica, and she's in a different time zone, and it's 1 o'clock in the morning for her here. So I'm gonna read her question that she asked earlier this week, and the answer that I posted in my story. You think the shirt's backwards, Jean? Maybe. I don't know. I guess I'm fragile like a flower and fragile like a bomb. I'm not sure. It depends on my mood. Anyway, so I'll read you guys her question. I'll read you guys my answer that I posted this week, and then we're going to get into it. I have some very specific pages from the determination and order that, visually it's backwards. It's I guess it's an IG thing. So really, you guys see my left and my right side is swapped then. It's really the right side of my face. Anyway, so then I'm going to go straight directly to the determination and order from the OPMC, and I'm going to go over what their reasoning was, at least what they referenced in their determination and order as to why they determined that branding was the practice of medicine, and I'll show you guys that on my computer. So it'll be an exciting conversation. If you guys have any questions, please feel free to just jot them down as we go. But quick little intro for any of you that have not listened in or have not heard these videos before, go to my website, drdanielleroberts.com. There is a little link for sovereignty. Under that, there is a link for trial by media, for malpractice or trial by media, and there is a little link there for a YouTube video where I go over my whole scenario, my whole situation, and what we are talking about, why I'm talking about it. So essentially I was canceled or defamed in the media. It greatly influenced the legal system, the politicians like Governor Cuomo and the legal system, and that led to them wrongfully revoking my medical license and using reasons from my personal life to revoke my medical license in my professional life. So that creates an incredibly dangerous standard, not just for me, but for any state licensed professionals, that they can essentially, an administrative board can essentially take away the license of a state licensed professional if they don't agree with what's going on in their personal life. So I'm currently doing an Article 78 to appeal the decision so that decision does not stand for anybody else in this country, and they can't do that to somebody else. So that's the reason I'm having these conversations ultimately. And you guys can check out my website. There's also a campaign page or a fundraising page so that I can pay the legal fees necessary to complete this Article 78. And without further ado, let's get into it. So you guys asked some really great questions this week. I also had actually my teaching attending when I was in residency, Dr. Jan Dower. He's been on one of my IG lives before, but he also asked some great questions this week that I posted on my story, and I'll talk about those on Thursday. But let's get into the question from Erica, and the question was a justification given as to why branding was considered medical malpractice? And what I wrote to you guys earlier this week on my story, if you didn't notice already, was the answer from the OPMC, the determination and order, was the brandings performed by the respondent while licensed as a physician were medical procedures in which standards of practice in medicine apply. So period. They just made the statement that that brandings that were performed by me as a licensed medical professional were medical procedures. Boom. And they list 5 different pages from the transcript in the hearing to justify why they're making that statement or what they're basing that statement on. So that's what I'm going to go over with you guys now. So the first page that they listed from the transcript, I'm going to let you guys see this so you can see. So the first page that they listed, this was just the question that was asked. The first page they listed was one, there's a lot of pages, but this was 1097. So we're going to go to 1097. I'm going to read you guys exactly what it says on 1097 so you guys can see what they're basing their decisions on. I was livid the other day when I was doing this. It's like my heart was beating out of my chest. I told Erica, I really thanked her for a question because I think when this first happened and they revoked my medical license, I was just so irate and so scared that I read through the whole determination and order, but I didn't go to all the footnotes and see the justifications for their answers. And there was a long answer for their justification, their determination and order, which I'm going to pull up for you guys too. So, okay. So here's the determination and order so you guys can see it. Make sure you guys can see what I'm seeing because I can't flip the camera or I don't know how. So here's from the State Department of Health. Jeffrey Conklin was the prosecuting attorney. My attorney was and is Anthony Scher. And this is in the matter of Dr. Danielle Roberts DO. And here the top part states about is how they've determined that they're going to revoke my medical license with no other reparations, and I need to return it by so-and-so dates, blah, blah, blah. So here's the determination and order. It's a total of 58 pages. It is a public document. It is on the Department of Health website. I don't even necessarily recommend that you guys read this document because it's just such a pile of crap. I know you guys weren't in the hearing, so it's hard because you don't get to hear all of the evidence, but a lot of the determinations they made, and actually I'll go one by one. At some point, we're going to take this one first today, and then I'm going to dive into this more and more, but you guys will see the determinations they made were based on faulty information or information that they misinterpreted on purpose and the information that they took from their expert witness and what the cross-examination was like. So I'll go through some of that stuff with you. But the first thing we're going to focus on, hey Holly, how's it going, babe? They found a way to make this ruling up. Exactly. So you guys are going to see, this is hilarious. It's not hilarious. It's horrifying, but you guys are going to see, I'm going to read these pages to you right now. So what I just read to you is out of the determination and order, which, as I said, was the brandings performed. It's number 14 if you guys read the document yourself, but number 14, the brandings performed by the respondent while licensed as a physician were medical procedures in which standards of medical practice apply. Boom, that's their statement. And here they have 5 pages they justify that with. The first page is 1097. So we're going to 1097 right now, and I'm going to read you guys page 1097. except I'm 100 pages off. Hold on one second. 1,168. Okay. 1,080, 1,086. 1,097. Okay, so this is an expert testimony by Dr. Richard Grant, who is a plastic surgeon. Hey, Jeff, how's it going? Hey, Antonio, nice to see you guys. Baron, I haven't met you before either, so I try to get everybody's first name. If you guys can just, I don't know if that's your whole name or what your whole, I hate referring to people by their IG handle. So if you just want to drop your first name in there, then if you ask questions, and I can refer to you guys by your first names. So this answer, hey Antonio, this answer is from their expert witness. This is the prosecutor's expert witness. And just to give you guys a little bit of background on what this experience was like for me. So he's the head of plastic surgery. Hey Jeff, he's the head of plastic surgery. He has been teaching residents and doctors plastic surgery for many years. The plastic surgeon that I worked with when I was in my residency, you do rotations in all different, you have to do rotations in all different modalities to be able to become a licensed physician, pediatrics, I'm family medicine, so I have to see a wide range of all the different specialties, so I would know how to refer my patients into those specialties. So the plastic surgeon that I worked under him. So when I went into this hearing, I called the plastic surgeon that I worked under, that I had a good relationship with and I was friends with, and she wouldn't even consider testifying for me in the hearing because Dr. Grant was testifying against me. So the prosecution had gotten to Dr. Grant and told him, and of course the media, remember what this whole milieu looked like, right? So the environment of my situation was this international defamation campaign, a U.S. federal case being prosecuted, prosecutors threatening people not to testify, people losing their jobs, all sorts of different things happening, that these expert witnesses that were approached by the prosecution most certainly is reading the media. They're reading all of the hellacious things that are being made up. They're seeing all of the lies, and then they're being asked if they'll be an expert witness in this case, right? And they're supposed to be unbiased, but my experience of Dr. Grant in the testimony was he certainly seemed determined to make sure that this determination was made, that my medical license was taken. And again, remember, I do believe that Governor Cuomo made a phone call to make all of this happen. So I don't even know what other connections might be there. So that's just kind of some background of how, trial by media starts to happen. Is this malpractice? Did I really do something wrong? Or are all the factors in trial by media, the politics, how the media influences even the expert witnesses, does that all factor into how these board members made their determination in order and based their decisions on this particular gentleman's testimony? And I'm going to share the testimony with you right now so you can tell me whether you think this is actually a substantial testimony. And I'll also give you guys a little bit of background. I'll add in some of the details of what the other, the expert witness on my side of the hearing and, some of the other information to kind of fill in some of the gaps. But hey, Kara, how you doing, babe? Thanks for joining. Okay, so back to the actual 1,097. Dr. Richard Grant, he's a plastic surgeon, as I said. The question is, I want to particularly call your attention to the medical procedure which would involve the use of an electrocautery pen, assuming that the device is being used in conjunction with a medical procedure for a legitimate purpose in an office-based setting. What are the standards of care? That question was withdrawn. Mr. Conklin was asking the question, who's the prosecuting attorney. He withdrew the question. And then he asked, what would have been the standards of care under the circumstances in 2017 and before? Dr. Grant's answer: the first standard of care has to do with physical environment itself, that the room is one that is properly terminally cleaned at the end of the day, as well as cleaned in between each procedure. You use electrical power into the room. The lighting, the various things need to be monitored to make sure that the energy output of the cautery device is not such that it is going to cause an electrical failure or cause other issues with other devices that are plugged into the outlets in the room. Does that have anything to do with whether branding is the practice of medicine? So that's the first page I'm going to read to you guys. My commentary on this is essentially his answer. The question presupposes, number one, this question has nothing to do with, is branding the practice of medicine? This question presupposes the assumption that branding does have to do with the practice of medicine, that this was a medical procedure, and now you have a plastic surgeon answering the question as if branding was the practice of medicine, and he's answering what the standards of care should have and would have been if this were a medical procedure. So if this were a medical procedure, you would have had to have the proper physical environment. The room would have had to be properly terminally cleaned at the end of the day, just like in a surgical suite in a hospital. Again, this is a surgeon speaking about this. So he's speaking as if this were some sort of surgical procedure. And then he's talking about the electrical lighting in the room and power outlets and all of that. Now remember, this is done in tattoo parlors all over the country. Is the room terminally cleaned in a tattoo parlor? Is it sterilized in the way a surgical suite is? No, because this isn't the practice of medicine. But they're using this testimony, this page from Dr. Grant, to justify their statement that branding is a medical practice that was done by me and revoking my license. Okay, that's page number 1. So that's the first citation they used, 1097. The second citation they used is 1109. Do you guys have any questions about this one? Hey June, how's it going, babe? They can't just make this stuff. They can't just make this stuff up for this. I know. There would have to be specific law written up for the future. They can't just suddenly make it up. Well, Jean, they are. I mean, this is literally, I'm reading to you guys the justification for their statement. Brandings performed by the respondent while licensed as a physician were medical procedures in which standards of medical practice apply. So far, we've only heard what the standards of medical practice are from their expert witness, the surgeon, but we haven't heard nothing about why branding is the practice of medicine. So I'm going to read you the second citation, 1109, in 1 second. I believe India's mother had a part in this too. She had used her power and connections to assist in this. That may very well be the case, Kara. That may very well be the case. We find out more information all the time that is so incredibly troubling to me. But she certainly did have a lot of connections. I know that Dr. Jan Dower, who was I mentioned him earlier in this talk, who was my attending when I did my emergency medicine rounds, he knew Catherine Oxenberg, believe it or not. But he has been very supportive of me and in this whole process, incredibly supportive, and just doesn't understand why these decisions are being made. He had even called Cuomo's office. He grew up with Governor Cuomo, and he called Governor Cuomo's office several times when I had written a letter directly to him, letting him know that this is a misunderstanding, that these women are telling lies in the media on national television about what had happened. I wrote him a very vulnerable letter asking to speak with him about this. And his childhood friend called him multiple times at the office. He never responded, never picked up the phone, never called back, never nothing. So it's just, I'm sharing these things with you guys because I don't think a lot of people understand the connection between the media and the legal system. They think if a legal decision is made, that must have been made justly, that must have been evaluated objectively by legal process, and certainly there was no influence by the media, and that can't be further than the truth. I mean, we're all humans. We all have our own personal agendas. You know, Governor Cuomo wanted to be elected and be, you know, whatever he wanted to be. His primary interest was not necessarily protecting the good citizens of this country or doctors of this country. And certainly Catherine Oxenberg, Sarah Edmondson, all the people from HBO, Jahan and Kareem and everybody that created the Vow production. I mean, all of these other people have their own agendas in this process. And unfortunately, there is a tremendous amount of oppression for anybody who went against the narrative in the opposite direction. So making it up is unconstitutional. They have to make it law first. They would need to show you the law and where it is in the law. Yeah, this board, you know, essentially what I was told in terms of that, Jean, this board, the administrative board, is utilized to be able to evaluate and make decisions that are in the gray area, essentially. But that's exactly why I'm doing the Article 78. We're taking it to a court, you know, an actual court, criminal court, not an administrative court, not, you know, this board. I'm not appealing to the board. I'm appealing to the court in the state of New York, the Supreme Court in the state of New York, and they'll have to decide whether the OPMC's decision was a constitutional one, whether branding is in fact the practice of medicine, and if they had jurisdiction over this case. So that is essentially what the fight is about. But yes, it's extremely frustrating, and for them to rule on something that there's no law about. And in fact, the states that do have, there are several states that do have guidelines regarding branding and the practice of medicine. And the ones that have taken the time to evaluate it and think about it have the way that their guidelines are written lean towards branding not being medical practice. So, yeah, it's been an extremely frustrating process, but this is the process we have, this is the system we have, and this is what we're dealing with. So the second one to justify, so here's the second citation. So again, justifying that branding is in fact a medical procedure in which the standards of medical practice apply. So the second one is 1109. So let's go to 1109. Erica, I can't wait for you to watch this. Look at, you're getting all your questions answered. 1109. I'm so glad you asked me this question. Okay, 1109. We're still in Dr. Grant's testimony. This is still Dr. R. Grant's testimony, expert testimony for the prosecuting attorneys. And here it's the first line is not a full sentence, so it just says of care for medical procedures, and says, are those standards of care applicable to physicians who perform less invasive procedures such as ear piercing, belly button piercing, and breast tattooing after breast reconstruction surgery? So here, the conversation, to give you guys context, the prosecuting attorney is asking him about the standards of care for medical practice in regards to less invasive procedures like ear piercing, tattooing, and belly button piercing. So those things, piercing, you do need a license in New York State to do piercing or tattooing. You do not need a license in New York State to do branding. So that's the first thing that we need to clear up. Okay, so here they're asking Dr. Grant, they're asking him again, not whether branding is the practice of medicine. They're asking him what the standards of practice are in relation to less invasive procedures. So here, they're lumping in, without even stating it, they're lumping in branding to those less invasive procedures like ear piercing, belly button piercing, breast tattooing after breast reconstruction surgery. Okay, so they've not stated why that branding is the practice of medicine, but they've lumped it in, and now they're asking him what are the standards of care for the medical procedures. Hey Barrington, what's up? So he says, so his expert testimony, this is Dr. Grant's testimony. He says yes. Does the standard of care change in any way because they are less invasive cosmetic procedures that you have described are able to be performed by non-physicians? So, okay, so here what they're saying is, so let me read it again. Sorry, that was broken up. So he answers yes to the first question, then which is do medical standards apply to less invasive procedures? Yes. Does the standard of care change in any way because the less invasive cosmetic procedures that you have described are able to be performed by non-physicians? So they're comparing it to tattoo artists and piercers and all of that kind of thing. So because you can get your ears pierced at Claire's jewelry store, they're asking, do the medical standards change because those procedures can be done by non-physicians? So he says no. Are body piercings and tattooing techniques taught by physicians as part of their medical training involving plastic surgery? Yes. Can you describe what that training involves? Similar to the training that we talked about for the use of electrocautery device. Typically, there are didactic components, a lecture, curriculum that describes the indications, the process, etc. So what they're using, so if you guys following this, what they're using to justify that branding is the practice of medicine is comparing it to body piercing, tattooing, and ear piercing. And they're saying that because those things are taught in medical school, because those things are taught to, they're taught to a very small population of doctors, but they're taught to plastic surgeons, apparently, according to Dr. Grant. I have never taken any classes that had anything to do with piercing, tattooing, any of that stuff. But they do tattoo eyebrows in plastic surgery. They do tattoo like eyeliner. They do certain cosmetic procedures that involve that. So very likely a small subset of physicians are taught those things. But again, those particular things, ear piercing, tattooing, you have to be licensed in New York State to do those things. They are, in fact, taught to those plastic surgeons. I bet there is a medical, an insurance code for those procedures. And none of those things exist for branding. So branding, you don't need a license in New York State. It's not taught by any medical institutions. There are absolutely no classes about branding at all whatsoever. Yes, you can learn as a physician how to use an electrocautery device, but you learn to use that electrocautery device to stop bleeding, to remove skin tags, to do small skin procedures, things like that. You're not learning to use the electrocautery device to create a scar. And it's a very different process. And if you speak to the expert witness, one of the expert witnesses I had, who is the premier branding artist and body modification artist in all the United States, he's the one who taught me how to do the process. He explains very specifically how different branding is using an electrocautery device to create a scar versus using an electrocautery device and trying not to scar the skin as a cosmetic procedure as a plastic surgeon would use. So these are very different processes. But again, this is what they're using to justify that branding was the practice of medicine. So let me see if there's any other comments I have about this. Any other comments or questions on this one? This is a little bit closer to home. You can see like how they're lumping it in a little bit, but what they're not giving in their justification are the distinctions between branding, piercing, and tattooing. I think the biggest one being that branding, you don't need a license, and it's certainly not taught in any medical schools or anything in the way that piercing and tattooing might be in a small subset of plastic surgeons. So let's see. What documents are the other states' laws printed? Kansas. I'm gonna have to go back and look for you, Jean. It's been a while. I think it's Iowa. I don't know. I'll have to go back and look for you. I don't want to give you the wrong ones. Hey Randy, what's going on? DM. Gosh darn it, I don't remember your first name. If you can write it in the thing, let me know. I don't remember it, and I hate that. I'm sorry. Jean says, lumping it in is careless, unprofessional, and ridiculous. Shame on these lawmaking wannabes. I do think this decision was difficult for them, but I also think that it was cowardly. I think they really went with the majority on this one. I think one of them in particular, the way he asked his questions, I think he knew that this wasn't the practice of medicine. I don't know, my opinion, but are these idiots writing stuff in crayon? Oh. It's sad. It's very sad. But this is why we're having this conversation. I think we need to have a little bit more courage, a lot more distinctions. Okay, so I've read to you guys. My stomach hurts, man. This stuff stresses me out so bad. But I have tools to fix that. Breathing being one of them. Okay, so those are the first two citations. The third citation is 1112, page 1112. I don't know, Jean. I know. I'm trying not to be mean. I know. It's hard not to be mean, right? I do feel like they're idiotic decisions, but it's, I think they're just people either having a really hard time making distinctions or just really not having the courage to go against the grain. And I can relate, like I said, my stomach is turning right now. It takes something to stand up against the grain. So I don't know. I like them. I like all the doctors that made these rulings against me. I think they were trying to do the best they could with what they had. I just don't think that they made the right decision at all. And we can talk more about them. I mean, we don't have to do it right now. I think we've been talking for 40 minutes and I want to read the rest of the citations, but maybe we will talk about that in another session. Okay, so now there's three more, so we'll go a little faster. So the next one is 1112. Okay, so let's go to 1112. And their next justification is still with the same expert witness, Dr. Grant. And the question is, what's your opinion? And his answer is sorry, my screen just went blank for a second. I just think we know that. When one is given the privilege of being a physician, that comes with responsibilities. You can't decide when you're going to enjoy those privileges, but not have the responsibilities. I know of no doctor who can say that they can compartmentalize their life as a physician to such an extent that one part of their life they are a doctor and another part of their life they are not. And we've talked about this before. We had a whole conversation about whether this changes because a physician is doing the branding or not. And I told you guys some of the metaphors. Like if I'm an aerobics instructor, right, as well. So I'm an aerobics instructor. I teach spinning, I teach kickboxing, I teach these other classes, but I'm also a physician. So if I'm teaching my spin class and I have people coming into my spin class, and let's say one of them drops dead from a heart attack, I didn't do a physical exam when they walked into the room. I didn't find out their medical history. I didn't do certain things that I would do if they were walking into my office as a patient. So should I lose my medical license? Am I held accountable to a medical standard while I'm teaching aerobics? Am I always a physician? So that's exactly what they're saying here. They're saying once a physician, always a physician. You can't decide when you have the responsibility. If you enjoy the privilege of being a physician, you can't decide when you have the responsibilities of being a physician and when you don't. But I very much beg to differ. I mean, if you are a human being and you play different roles in your life, you have different jobs and different roles, you absolutely have a different standard to operate under. It doesn't mean if that person fell off my spin bike that I would let them die. Because I'm trained in CPR, because I'm a doctor, I would absolutely go right over and help that person. I'd probably get in trouble for it. But I think protecting the gift of life is way more important than covering my ass. So I would do it anyway, which is clearly why I'm in the position I'm in. However, if I were teaching an aerobics class and I didn't do a history and physical, or I didn't treat these people, if I did treat them as my patients, it would have been inappropriate. It would have, first of all, we never would have done the class. If there's 30 people in my class and I had to do a history and physical before every single client came into the room, we would never have the spin class. That's why before they come to the gym, they see their doctor, they sign off on a medical clearance, and they take the risk and liability as to whether or not they can participate in that spin class. So clearly in that situation, I'm not acting as a doctor. I don't have the same responsibilities. I don't have the same standard of care. And in fact, if you applied that standard of care, it would be inappropriate. So I think, again, they're using this to justify taking my medical license. You know, they have a very distinguished, a very educated, a very long CV expert that has been teaching plastic surgery to people. And he gives his opinion, you know, that you can't separate, you know, once a doctor, always a doctor in every role in my life, you know, even if I have a dinner party. You know, if I have a dinner party, if you guys are invited to my dinner party and I cook, I'm going to have to do a history and physical on all of you. Every single one, where I need to know your allergies, your food allergies, because I will be held liable and they'll take my medical license if you guys have an allergic reaction to my food. Because once a doctor, always a doctor. You know, and the board members, clearly, that were evaluating this, when they go to Great Adventure, they do a physical exam on their grandson. They go to Great Adventure with their family and they make sure they do a whole history. They do all this stuff to make sure that they're going on the rides. If they're going to go on the rides that risk heart attack or adrenaline rush. No. You know, you do not uphold the medical standard of care in every aspect of your life all the time. We are human beings. We play different roles. We have different responsibilities, and there are different standards that we adhere to. And it would be inappropriate to apply medical standards in every situation. It would be uncomfortable if I were to start asking history questions of my spin students. I would be brought up on some charges for invasion of privacy. HIPAA violations. They're not my patients. They have to be contracted with me, have an agreement to be my patients. Okay, I'm done with this one. So, you're on different clocks, Dr. Aruba. Yes, exactly. That is what it is like, a friend suing me as an RT because they die of lung cancer from smoking because I was responsible for helping them. That is nuts. Yes, Desiree, you totally got it. Exactly. And that's what they're basing these decisions on. So I'm just going to read the rest of the page to you guys for completeness sake. So the next question is, when Dr. Roberts branded the DOS women with the electrocautery device and based upon her background, training, experience as a physician, the fact that she was licensed in the state of New York as a physician, do you have an opinion as to whether such branding constituted medical procedures? Yes, I have an opinion. What is your opinion? That the branding procedure was a medical procedure. So there you go. That is what they're basing this decision on. So the OPMC is saying branding is a medical procedure because this expert witness, our prosecuting expert witness that has been influenced by the media and has his own agenda, has an opinion, and his opinion is that this is a medical procedure. So there you go. Now, I had an equally as credentialed, in fact, a higher, I believe, a more impressively credentialed expert witness that testified for me, who was both a plastic surgeon, a physician, a surgeon, who had a second board in plastics, and was a lawyer. So he knew law and he knew medicine. And he had the exact opposite opinion of Dr. Grant. Why aren't they stating that in their citation? Why is his opinion less than Dr. Grant's? It's heartbreaking. Okay, 2 more pages to go, guys. Hang in there with me. We're going to make it in under an hour, I promise. I can't wink. It would look sexy if I could. Gotta have a little fun with you guys. Okay. Next one, my stomach's still churning. Okay, 1129. 1129. Let's see why else they are choosing, or how else they're choosing to justify that branding is a medical procedure. 1129, 1123, 24, 27, 28, 29. Okay, here we go. Dr. Grant. Same expert witness. Haven't looked at any other expert witnesses. This was a 12-day or 11 hearing process. They've looked at one expert witness's testimony to determine that branding was the practice of medicine. One. Okay. Same expert witness. Here we go. Upon the deviations from the accepted standards of care for performing a medical procedure using an electrocautery device, were those risks of harm to the individuals in a room with Sarah Edmondson the same as you have testified? Yes. Okay. So what they're saying here is upon the deviations from the accepted standards of care. So they just used his testimony to justify that this was in fact the no, I didn't. Okay, I'm going to answer these questions. Hold on one second. I'm sorry, Baron, what's your first name, babe? Just so I can, I don't even know if your name is Baron. I'm going to just say that because I can't pronounce your IG handle. So if you could let me know your first name, that would be awesome. But no, I learned to brand not from another doctor. Doctors are not taught how to brand. It's not a medical procedure. There's no ICD-9 codes. There's no insurance codes for branding. It's not a medical procedure. It's not taught in medical schools at all. I learned to brand from the most world-renowned or nationally renowned body modification and branding artist in the United States. So that's how I learned that. I have to bail, D. Okay, babe. Thanks, Jean. Thanks for coming, honey. I know it's a little long this time, but I'm going to finish it just so we can finish the whole thing. So upon the deviations from the accepted standards of medical care, so first they used his testimony to justify the fact that in his opinion, branding was in fact a medical procedure. So they've established that, they've accepted that as truth because that was his opinion. Now they're saying, based on that decision, they've asked him a bunch of questions about how my process deviated from the standard of care, because clearly I didn't do it in a hospital room or any of those things. So there's a bunch of deviations from the medical standard of care because this wasn't a medical procedure. And now he's saying, upon those deviations from the accepted standards of care for performing a medical procedure using an electrocautery device, were those risks of harm to the individuals in a room with Sarah Edmondson the same as you have testified? So they're just basically, confirming that I should have somehow used the same standards of medical care in the room with Sarah Edmondson as Dr. Grant would in his medical procedures. He answers yes. Does Dr. Roberts testify that sterile technique was not required or necessary and no medical standards were imposed or guidelines applied from this type of very non-invasive process? What is your assessment of her testimony of the description of the branding that took place? So one, I need to clarify my testimony. First of all, I did say it was a low invasive process. So that was the first thing. And second, I did say that it was not required for the medical standards to be imposed because it wasn't a medical procedure. They make it sound here like I'm saying sterile technique was not necessary, which is not what I was saying. And in fact, I did use sterile technique because you do that in this process, not because it's a medical procedure, because you do that in a tattoo parlor, you do that anywhere in this process. So I just want to clarify that. So he says, to their question, he says, I disagree. A physician doing a medical procedure like this, of course, the standards of medical practice apply. So here they're justifying, so one, they justify that it's a medical procedure. Two, the standards of medical practice apply, and they would in fact apply to this process. So that's the second part that's the second part that they use to justify this decision. And I have one more page, I think, for you guys. Let me just see. Yeah, one more page that they use to justify this. So Randy asks, could you have used a numbing spray to lessen the pain? Sure, I could have. But that wasn't what the women wanted. That wasn't the purpose of going through this. This wasn't a medical procedure. These people didn't come here for an aesthetic. There was an aesthetic process, there was an aesthetic look, but that wasn't the reason they were doing the process. The process was for them to gain the self-esteem that they could face pain or go through a scary process and have the strength and the courage to do that so that they could experience themselves in a way that they haven't before. So, using numbing pain or some sort of numbing spray or some sort of anesthesia would defeat the purpose. It's the same thing as like the Omegas, Michael Jordan and Steve Harvey and all the guys that are in the Omegas. If you brand a guy in that, nobody, if these were men, and clearly nobody has questioned it with the Omegas, if these were men, nobody would be asking, could you have used numbing spray? Did you not? You didn't want to break these little men, right? You could have used numbing spray, right? No, you're asking that question because these are women that need to be protected. These are women that are breakable. And that's why this is an issue. I mean, this wouldn't be an issue if these were men. This clearly wouldn't be an issue. So the last page that they're using to justify that branding is the practice of medicine is 1163. And if we look at page 1163, it says,
I'm going to meet Shona for dinner.
Okay, honey.
We'll be back later.
All right. Bye.
You look pretty.
Thank you. So the last one says, okay, so this one's actually very important. We're going to probably have to use a whole nother session for this. I'm just going to read it to you guys. But the question is, are there nerve fibers in all the layers of the skin? The answer, this is the same expert witness, Dr. Grant. Yes. Could that have enhanced the feeling of pain that she is experiencing when the touch-ups are done over the area that has already been burned? Yes. That's an inaccurate answer, I believe, by the plastic surgeon. After you do electrocautery, you burn the top layer of skin, you kill the nerves in the top layer of skin. Those nerves are now dead. They're not going to feel pain. So he's saying the opposite of that. If we stop it here, the next question is, if we stop it here, we see the women in the back who appears to be sitting on Miss E's left leg. True? So they're looking at a video of the branding. And he says yes. And the question is, Dr. Grant, you have testified in your opinion that the branding constituted medical procedure and that the deviations as you described were severe. Does this video confirm the opinions that you gave? Yes. So now, based on video evidence, he's, in his opinion, this is a medical, remember, the entire thing, the only bit that they used to substantiate that branding was the practice of medicine was Dr. Grant's opinion as a surgeon that this was in fact a medical procedure. And I've given all the distinctions as to why that's not true. But once they established that, then they established that medical standards would have been imposed because this was a medical procedure. And now they're using the video evidence of the branding process to say that the medical standards were not applied. And the ones that they're saying, they're not specifying which medical standards were broken on this page or which were not adhered to on this page, but they're just saying that the deviations were severe. And now they have on record Dr. Grant stating that I deviated from the medical standard of care severely. So, of course, I did, just like I do in my aerobics class. I don't uphold the medical standard of care in my aerobics class because I'm not acting as a doctor. So, in this process, I did not adhere to the standards of medical practice because I was not acting as a doctor. I did, in fact, use absolute professionalism. There was very clear communication. They knew this wasn't a patient-physician relationship. The room was clean. It was sterile technique was used. All of the things that you would do in a tattoo parlor were absolutely done well. And every single woman that had a brand done by me, not one got an infection. Not one. Now, that's not the same I can say for the other women that got branded through other practitioners, through other tattoo artists. But I can tell you that the brands that I did, there weren't any problems with. So clearly I upheld a standard, but it wasn't a medical standard because it wasn't a medical procedure. And that's why they're taking my medical license. That's how they're substantiating that this was the practice of medicine, and that's how they're saying that I did not adhere to the medical standards and are taking my license and my entire career for that reason. So I hope this was informative. I feel like I'm going to throw up. I hope this was informative. I hope this was helpful. Erica, I hope this was helpful for you and your question as well. It'll be on video so other people can watch this. Again, if you guys have people that have been treated wrongfully, if the media has influenced their legal trials, if they've not been evaluated properly, if they have been discriminated against, I would love to hear their stories. Please have them get in contact with me. Also, if you guys have other questions, or if you guys want to get involved in any other way, please DM me. I would love your support in order to turn this decision around, this wrongful decision around. I need to pay my lawyer and I need to do it soon. I'm still waiting for him to respond to me on what the timeline is, but they have moved the timeline up for us to get the brief in for the Article 78. So if you guys were thinking of contributing, if you guys want to contribute, if you want to make sure this standard is reversed and they can't do the same thing to you or to any other state licensed professional, CPAs, insurance agents, doctors, lawyers, all of you, every single doctor listening to this, you guys should want this to be reversed. Please bring your doctor friends to listen to this. Send the video to them. Send this information out to every single doctor you know. And please have them go to my page to contribute. Because if this precedent stands, they can absolutely do this to them. They can cite my case. They can say, we can peer into the private life of a physician. If we don't like what they're doing, we can take their medical license because of it. And we can do it because of what's in the media. So please send this to your doctor friends. Send this to your lawyer friends. Send this and the other branding videos. Send my YouTube video. Please, please, please get people back to this site. Please contribute. Go to my website, drdanielleroberts.com. Hit the Get Involved button. It'll take you right to the campaign page. You guys can donate there. You can donate with your name. You can donate anonymously, whatever you want to do. But let's make sure that this horrific precedent is reversed so that nobody else is hurt in the way that I have been, especially underneath a precedent that was set by me or by the case involving me, not by me, that's for sure. I love you guys. Thank you so much. Little shout out to my little warrior RJ, who's with me all the time. I love you guys, and if you have any questions, DM me. My courses are still going. If you want to take a course with me and become invincible, become resilient, become healthy, DM me for those two. Obviously, any monies that I earn in that are going to my legal battle right now too, so you'll be contributing to two good things: your own health and well-being, your own growth, and reversing this precedent. So I love you guys. Have a great day. Thank you for sticking with me for the whole hour. You're amazing. I'll talk to you guys soon.